I always forget. I forget to go off.
Oh, that makes it more interesting.
Oh, well,
I'm
or
used to
maybe
having
not.
committee assistants who do that for me, and now I have this committee assistant new rules. I have to say it.
Got it.
And at 5 o'clock, I don't always remember.
So welcome back. We're continuing our work on H55, and we're going to begin with Vermont Legal Aid. Kelly is going to start us off, then we're going to go to Cam, and then we're going to Emma, Common Good. So, and then we're going to shift at 11. We're going to move to H217 and 101, which is kind of embedded in it, or embedded hopefully in the work we're going to do. So let us start. Kelly, we kick it up to you in remote land. Welcome. It's lovely to have you.
Thank you very much.
So, thank you. Introduce yourself and tell us what give us your input on 55.
Sounds great. So for the record, my name is Kelly Kazmarski. I'm a staff attorney at Vermont Legal Aid in the Poverty Law Project. I'm here this morning to voice legal aid support of H55. We are particularly focused on the portion in section 6 related to the expanded eligibility provisions to expand eligibility in unemployment insurance coverage for folks who become unemployed due to urgent, compelling, and necessitous reasons. We learned a lot during the pandemic about the importance of helping families through temporary emergencies and to expand the coverage of unemployment insurance to include these folks who are facing essentially family crises in urgent, compelling, and necessitous circumstances really implements the lessons learned during the pandemic and makes them apply in post-pandemic times. So we fully support, legal aid fully supports the expansion of the eligibility criteria for unemployment benefits. As I believe Representative Mulvaney-Stanek testified earlier, if there were a way for this committee to obtain the accounting and financial impact information that the study in H55 seeks to determine. If those numbers were available now, perhaps, we would urge the committee to, in fact, go ahead and pass the legislation that would expand the coverage rather than working on a study right now. However, the study that H55 currently compels requires that the Department of Labor consult with the Joint Fiscal Office to answer the questions that Damien reviewed in terms of the cost, the number of folks potentially impacted, and legal aid would welcome an opportunity to be involved or to provide information for the department and the JFO to use in preparing this report. As the largest agency working with unemployment claimants in the state, we do believe we have some important anecdotal information to contribute. In our experience over the last several years with multiple advocates working on unemployment issues, we were able to come up with a list of about 10 or 12 of our clients that we believe would have benefited from an expansion of the unemployment insurance program to include folks in the urgent, compelling, and necessitous circumstances. Granted, we do not talk with every unemployment claimant in the state. However, we have represented thousands of claimants across the state over the last several years. And so our legal aid's impression is that the expansions proposed to eligibility would not have significant impact on the trust fund. It would not be a large number of folks that would suddenly become eligible for benefits. And it is, in fact, very specific situations when this eligibility would come into play. And it's important to remember, too, that the expansion contemplates only folks who would be able and available to work, which is a federal requirement for receipt of unemployment benefits, so that this coverage would really help families when the crisis has passed and the worker is then able and available to work. For example, a sick parent, a sick spouse, which causes someone to actually lose their job, right now would not be covered by unemployment benefits when that person becomes able and available to work again. So we support the expansion. We, Legal Aid, would be happy to be involved in any way that we can to assist with the report that H55 contemplates. And I would, as Representative Mulvaney Stanek stated, urge the committee to inquire whether some of that information sought in the report might be available since the last testimony on this subject back in the House committee. So with that, I'd be happy to answer any questions.
Well, I think you gave us the information. I mean, I think we are going to be, our next witness, Cam, is going to certainly, I hope, update us on some of those numbers. How long has it been since the testimony was taken in terms of the numbers and the impacts and the costs that they didn't have at that point in House Commerce?
Cameron would probably be able to say better, but it's been a few weeks anyway. I believe it was sometime in early to mid-March.
Okay, okay, we will ask Cam when he comes today. But I think you gave us your Vermont Legal Aid numbers, which were 10 to 12 of your clients would have benefited. So in terms of your numbers, I mean, you deal with how many clients a year? I mean, that's a pretty modest number.
It is, exactly. Yeah. I could provide more solid data for the committee if you would like, but just in thinking of my colleague.
Yeah, and I think if we move on this, Kelly, it would, and we asked you to participate, obviously, then you would be involved with that and bring everything you have to bear on that discussion. So anybody have any questions for Kelly?
Yes, so thank you, Senator Clarkson. So I actually would like, if Kelly does have more information, like I don't know the number of clients that you have, so what proportion 10 to 12 is, so that would be helpful for me anyway.
Kelly, give us a notion of how many clients you guys deal with in UI a year.
I think we'd have to, over the last few years, as a result of the pandemic and the claims that have come up in that sense, oh boy, I would say somewhere between 500 to 800 in 1 year. Thinking about the number of colleagues I had working on these cases, the number of cases I myself had, that is obviously quite high. Pre-pandemic, it was much lower. I was the only person at Legal Aid working on unemployment claims before the pandemic. And my caseload wasn't even that large at that point. So, but I would be, I'm sorry?
Yeah. A normal year would be a lot fewer than 5 or 8.
Correct. And I would love to update and follow up with more definite information from our intake folks about the number of claimants that we actually have served over the last few years.
Yeah, that would be great.
Yeah.
And then I have a question about, just because the unemployment, you have to separate from the employer, obviously. Mm-hmm. So it's kind of a permanent situation, but and I would expect that some employers and employees would prefer to stay with the employer, and so I'm wondering how the proposed leave or even existing paid leave programs, but especially the proposed programs, if you've had a chance to think about how those could cover people for the initial part of the emergency and result in employees being able to stay in their jobs, and employers not having to pay this out and to be able to keep people, because employers, it's a problem for them when you have turnover.
Costs money.
Absolutely.
And if that's, I mean, I can ask that question later in this process. We just started with this bill.
I think that's one of the big questions is what's the interplay between
Well,
leave, which, you know, and separation.
and
Right.
we have discussed this, my colleagues and I at Legal Aid a bit, and we do suspect that if paid family leave passes, it will hopefully incentivize employers to allow folks to go out on leave to handle these family emergencies, in which case they would not be eligible for unemployment benefits, because it's only when there's been a separation from employment that unemployment benefits are eligible. So if someone is on leave, there is still a job. There has been no separation. So we have discussed the fact that hopefully paid family leave would minimize the number of people who find themselves without jobs due to these urgent, compelling, and necessitous reasons. However, it would still be necessary to provide coverage because there will still be some folks who do lose their jobs for these urgent, compelling, and necessitous reasons. And for those folks, paid family leave will not help. They are not on leave. They have lost a job. They have separated from employment. And so the two cover very different situations in our view. Paid family leave is very important and we support it immensely. And we do hope it will encourage employers to use leave more liberally with employees facing family crises. However, H92 and the proposal to expand unemployment coverage would still be necessary because it would assist folks who have separated and completely lost a job for those reasons.
Okay, thank you. That's very helpful.
Right. Thanks. And I think with that, Anne, do you have any questions?
Yeah.
Randy, Keisha? Okay, great. Cam, would you be kind enough to join us? And because I think I'm all for not doing any more studies and trying to get the work done now. And I think I hear Wendy saying similar thing. If we can get this work done in section 6 done now, but it hasn't been enough time for us to get the data that we need to have that to come to that point. So Cam, would you be kind enough to speak to us on all of H55 and then maybe specifically to this issue and see what we could actually accomplish?
Yes, ma'am. Absolutely. For the record, Cameron Wood, Policy and Legislative Director for the Department of Labor. I also serve as the Unemployment Insurance Director for the department. Happy to be here this morning and talk to you about H55. I was taking a few notes as we were kind of walking through, so I'll do my best to keep my comments both organized and try to respond to some of the issues and questions that came up this morning. For starters, the department is generally supportive of what you have in front of you with H55. And I'll just kind of quickly walk through, you know, the high points here. For the small nonprofit piece, as was mentioned this morning, and happy to answer any more technical questions that you may have. Currently, small nonprofits, those with 3 or less employees, are not required to be liable for unemployment insurance and cover their employees. They can voluntarily elect to do so. Some of them have, but you know, it is true that those individuals may not be covered in the event they need to file for unemployment insurance. During the pandemic period, we were able to cover most of those individuals, but I think it is important to note that under normal times, someone who's laid off from a small nonprofit is likely going to be ineligible for unemployment benefits because they're not covered. So this bill would require that. It's a policy decision for you as the legislature. The department is understanding of the concern and the need to cover these people, and we're generally supportive of that. It has pushed it out for a year at the request of others, and we're supportive of that to give these individuals time to come into compliance and us to get the message out. So we're also very supportive of the work that's in the bill regarding the outreach to small nonprofits, the development of certain educational materials. We've been I've been in contact with Emma, and we've talked about, you know, what that could potentially look like and our potential ability to help support them in helping us develop some of this material. So I have little doubt we will lean on entities like, you know, Common Good to help us Haven't had a chance to really deep dive with the Secretary of State's office yet, but we've kind of contemplated as these nonprofits begin to register with the Secretary of State's office to make sure that we're putting information through the Secretary of State regarding this new requirement, along with the educational materials that we developed. So quickly, I just want to go to a point that was raised by the chair earlier regarding larger nonprofits and the concerns that she had identified with the pandemic and the bailout. So the way this works, as was mentioned earlier by Representative Mulvaney-Stanek and Damian, if you are a reimbursable employer, you do not pay taxes on the wages that you pay your employees. However, when you lay someone off, you will then pay dollar for dollar of the benefits that that person receives. Where it became very problematic for nonprofits during the pandemic that were reimbursable, you may be on the hook for those benefits for up to 18 months after the person separates. So we had a lot of nonprofits that were very frustrated during the pandemic because, let's say you are the nonprofit, I work for you, I quit, and then 6 months down the road, I get laid off from someone else, totally not related to you, but I am eligible for unemployment because of that layoff. Because the wages in my base period were paid from the nonprofit, you are going to pay for my benefits, not the employer that laid me off. And so there was a lot of frustration, not understanding that that was the reality during the pandemic. And we saw bills for certain larger nonprofits skyrocket into the tune of hundreds of thousands of dollars that they owed the department during the pandemic. The federal government fortunately did step in. They did provide 50% reimbursement for calendar year 2020, and then I believe for periods in 2021, it may have been late 2021, I believe that reimbursement was increased to 75%. So these nonprofits were getting some sort of relief, if you will, or bailout from the federal government in that sense. But as you can imagine, even covering just 50% of a $300,000 bill is still $150,000, and that's a lot for a nonprofit who, let's be clear, nobody planned for a pandemic of that magnitude. So I just wanted to comment on that. The reality is, smaller nonprofits have clearly smaller budgets, so we need to be very careful in ensuring that they understand the difference between taxable and reimbursable. So I just wanted to comment on that. The other pieces here, there's a section in here regarding the Survivors Transition Program, requiring the department to do more public outreach regarding that program. We are supportive of that as well. We recognize that, coming out of the pandemic, there's a lot of work that we can do to make sure individuals are aware of this program and eligibility for it. So we have already started working with our own staff to make sure individuals are aware of the program when they file their initial claim. And then we've also started working with I'm forgetting their name right off the top of my head, Kara Casey, the Center for
network.
Yes, ma'am. Already started working with them on ways that they can give us feedback on the materials that we've developed and how can we, partner with them to ensure that we're communicating with all of their members about the program and just trying to do more to get the information out. So absolutely supportive of that. So I will circle around to the last two pieces. The language.
Before we leave that, anybody have any questions? Because I have a question for you on the survivors piece. I think I understood from Damian's testimony that you're already in some informal ways using this and accessing this fund.
Yes, ma'am. So the way it works is right now, and we'll get into a little.
So my question isn't the mechanics.
Yes.
My question is, A, you knew about the fund, which was great, but B, how is the fund fed? Where is the money? It's different from the victims' compensation fund.
Correct.
So it's it's only got $25,000 in it, which isn't going to go very far. We have a lot more people accessing it. So how is that fund fed?
So we get an interdepartmental transfer from the Agency of Human Services of $30,000 a year.
Oh.
a year for this program. And so I do not recall off the top of my head exactly if that is just general fund dollars or if it's earmarked from somewhere else, but it's just
It's from AHS?
It is an interdepartmental transfer to us.
From AHS.
I believe so, yes, ma'am, and I will validate. We were discussing this just the other day in kind of anticipation of what we've seen a potential increase of utilization of this. Just very quickly on the mechanics, what the problem we were running into is we were not asking individuals about the program when they filed their initial claim. We were relying on the individuals to tell us that their separation was because of a potential domestic or sexual violence circumstance. So we were finding that people would get 3, 4, 5 months down the road to the appeals process before we would even find out that they're potentially eligible. And that's why we think that's why we were seeing very, very low numbers of utilization. And so one thing we did immediately was we started asking individuals the question on the initial claim. You know, we ask a lot of questions. What is your separation for? Voluntary separation? Were you laid off? Did you quit? And so we started to ask, you know, we want you to be aware of this program that exists. So if your separation is due to a domestic circumstance or sexual violence in the workplace or outside the workplace, you know, let us know. I'm paraphrasing the question here. And so what we've seen, you know, immediately we've seen, I don't want to call it a significant increase, but we've seen individuals start to answer yes to this question. And so our concern is, are we going to have enough funds available if we start to see a lot of utilization? It works the same way unemployment does. So your weekly benefit amount is based on your past wages. So you would be entitled up to $668, which is the current max, if that's what your wage history supports. So with the $30,000 a year, you know, that could only support, you know, a handful of individuals, 4 people, if you're averaging, you know, average weekly duration and regular UI. So we do have a little bit of funds that we've had left over, I believe, and I will want to go back and validate this, and happy to submit it back to you guys in writing this week. I believe we have about $200,000. So there is a little bit of
so
a
it's
cushion
added
there.
up over the years.
That is my understanding
So you're
from
able
my
to keep-
cashier's office. Yes, ma'am.
Okay, so you now have,
But
that would be great to know how much you have now.
yes, ma'am. But we do have a concern, and one thing that we want to look at over the summer with the other pieces under the necessitous language. If we're going to see higher utilization of the money, does it make more sense to simply allow these people to collect regular unemployment as opposed to having this special fund or special program? It may make sense to just have them in the unemployment insurance program. We're trying to explore that. You know, we just started having the conversation, you know, within the past 2 months about this. And so it's not something that we've been able to gather enough data or have enough of a conversation. So circling back to the kind of necessitous language, I don't have any.
Section 6. So this is the interplay between 6 and 7.
Can I ask you a question on that?
Yeah.
Do you have the flexibility to use, say, because that you had this situation, could you use the fund for part of the payment, say like half or 30%, so that you share? Do the federal rules let you do that?
You could do that. If we were to go down that road, my vote would be more to remove the program, allow these individuals to just file under regular unemployment insurance. And then if the General Assembly, if you all wanted to pay for a portion of those benefits, to just provide that money directly to us to put into the trust fund to pay that.
Oh, okay, because
That
that's
is possible.
simpler.
Yes,
So
ma'am.
And we could
okay.
conceivably fold what's currently there into the trust fund if we decide to just cover these people with UI
Yeah.
money.
Yeah.
Do you, it's the second study in this report, in this bill. It sounds like it makes some sense, given the federal interplay here, that we continue to keep section 7 as a study and look at section 6 as something that we may want to resolve now before the end of session. Is the time frame such that on section 7 it does need the report time?
I believe so, yes,
Okay.
ma'am. Because, so I have two primary concerns with this, the urgent, compelling, or necessitous language.
That's in section 6, and that's the one we're being asked to,
Potentially address if we have
Act
data
on
so
now.
far.
so,
We have not been able to gather any data on this because our system does not collect it. And so
so
we,
you're not gonna have any more data before the end of session for us.
yes, ma'am. Not any data that I would feel comfortable bringing to you for you to act on this language this session and make it law.
So this is the section 6, the necessitous,
Urgent,
urgent, compelling, or
necessitous.
necessitous.
So and so you all understand how this would work, and it was kind of alluded to, but I want to make sure it's explicit. If someone currently leaves their job due to some sort of personal event or circumstances, if they voluntarily separate, they're not eligible for unemployment insurance benefits. The purpose of unemployment was if you were laid off through no fault of your own by your employer. The concept there was not to cover personal circumstances that may impact your ability to be in the workforce. We covered these individuals during the pandemic because we were in an emergency situation, emergency posture. We wanted to make sure we were propping up the economy. I have two concerns: not having enough information about the impacts, where you're hearing from legal aid that they have 10 to 12 individuals. I think it's going to be significantly more than that. But I don't have data right now because we've only been talking about this for about 2 months. I don't have data right now to come to you and say, here's the potential. What I threw out to the House Commerce Committee was, let's assume it's up to 2,000 people. I don't have any data to base 2,000. I'm just telling you, we had 16,000 people collect unemployment last year. We've at the lowest rate of unemployment we've been in, even lower than we were pre-pandemic. So I think that's not a good baseline to go off of. Let's assume you take 10%, that's 1,600 people. Let's assume that you give them maximum benefits or even the average, and you average that out. I think 1,600 people, average benefits of $350 for the average weeks of 11 weeks, which is currently where we're at. I think that's I believe I did the math when I was sitting here, but I think it's like $7 million. So I'm not prepared to come to you and support spending $7 million out of the trust fund, given the current state the trust fund is in, without having more data. And I will not have that data to you by the end of the session, no.
So, and if you can't get that data, is it likely that, and we'll have JFO come in and testify also, but is it likely that JFO would have that data?
We are going to try to gather as much as we can. But what I was telling the House Commerce Committee was this is not an easy thing to do. If you wanted to know how many people potentially leave their job because they lack childcare or because they need to take care of a family member, we don't have codes in our system to flag those claims. So what we're going to have to do is we're going to have to start to manually track those or manually calculate them. And I'm just letting you know it's challenging to do. It potentially can be done, but it's not something that I would feel comfortable only looking at for a 2-month period and coming back to you and saying we have enough data. So it's something
And we
that
don't have 2 months right now, we have 4 weeks.
Yes, ma'am. I'm saying 2 months from when it was
Right,
in the
no,
house. Yeah.
I got it.
But correct, you have even less time now to the end of the session. So that's where I'm saying I'm supportive of what's here because it gives us, at least 6 months, 6, 7, 8 months to try to gather as much data as possible and to also look at the language. Because I'm also not supportive of how the language is written in its current form or as it was presented in H92 in the House. If you look at some of the other states, at least the states that I've been able to communicate with so far, some of them have similar circumstances that they allow, but the language is a lot different. It's a lot more restrictive. If you put language in there that says urgent, compelling, or necessitous circumstances, a lot of people were saying, hey, people who lack childcare, people who lack or need to leave, separate to take care of a family member. But those are only 2 examples. Urgent, compelling, and necessitous could mean anything. It could mean somebody's car breaks down and they have to separate, or they get fired, or they have to lay off from their job. So when people, when we come in and say, well, we only have a few clients that may fall into these 2 buckets, but that's not what the language says. The language is significantly broader than that. And so for me, I want to make sure that we're able to review what other states have, and potentially come back to you next year to say, we feel that we can support this because here are the number of claimants that we anticipate may be eligible, but we want to make sure we craft the language that to be a little bit more restrictive to ensure that we're not opening the floodgates to every potential circumstance. Madam Vice Chair, to your point, that's not something we can do within the next 4 weeks for you. So that's why I agree and appreciate doing another study is not something that we as a department want to do, but in efforts of trying to compromise on the goal here, we were okay with what the House put in here because it gives us a little bit of time to at least go review, work with the Joint Fiscal Office. Matt Barowitz and I have had a conversation with the Joint Fiscal Office already about this, and we'll have more conversations with them, including if this language passes, to try to come up with as best we can an estimation of what we believe the utilization would be under this language.
I suppose the other plus is that Matt will be back from maternity leave in time to help us with the data, which he may disappear at any moment.
Yes, ma'am, that is true.
Did you find?
Yeah, well, did you provide that language that you would prefer to the House?
I don't have it. I don't have it written out.
Could we, I mean, we have time to talk about that.
Sure. So for example,
I mean, not necessarily today, but some today, and then
so for
flesh
example,
it out a bit.
if you look at
Because I'd
Maine,
love
if
to.
if
Yeah,
you look at
yeah.
Maine real quick, their language specifically states the leaving was due to the, and I can send this.
So
Yeah,
section,
okay,
section
okay,
six,
cool.
we're on
So, but
section
it says
6.
the leaving
And
was
we're
due
in-
to the.
Well, he's reading from something in Maine.
Oh, I'm sorry. I thought you were looking at.
It
section
says,
6.
the leaving was due to the unexpected loss of childcare or elder care for which the claimant was not at fault and for which no work alternatives such as changes in hours or leave of absence or alternate child or elder care options were available despite good faith efforts made by the claimant to resolve the issue and continue working. I'm not saying that that's exactly what I would go with, but something that is
More
more
specific.
restrictive than just
I get
saying any necessitous circumstance that requires you to leave your employment.
Because that doesn't include the domestic or sexual violence.
And what we've talked about, I had a great conversation with Representative Mulvaney Stanek the other day. We will be looking at that as well, because I think that may make sense to fold in to unemployment as well. If you have to separate, just take the domestic and sexual violence survivors program and just incorporate that into UI.
So we could
potentially-
add that conceivably and blend these two studies.
If you would like to, I see them as the same. We will, well, in my mind, as I'm reading this, we will do the review of the necessitous language. We will do the review of the utilization of the current survivors transition program. It wouldn't surprise me if we write it in one report and bring it back to the legislature.
Yeah, because I think that would be adding an additional element to that report, which is the other consideration of just folding both into UI.
Yes, ma'am.
But we're already doing this sexual violence one. We're already providing.
We
that.
have it as a separate program. The question
It's
we're
a separate-
talking
Right, but
about
the
is,
state as a whole.
And the funding
have
for it isn't
experience
from
with
UI.
it.
The
Right, but we have
funding-
experience with it, so.
Right, exactly.
and we're talking about as part of the report, potentially just the department coming back to you and giving you a recommendation of whether or not to fold that into UI.
Right,
With some updates on what's actually happening.
okay.
Right.
Do you have anything else on 55 at the moment?
Very, very
Because then I'd
quickly.
love to turn to Emma before we go
Yes,
to.
very quickly, Madam Vice Chair, you had mentioned domestic partner. My recommendation would be if you want to clarify that or define that, to do it in statute. I would prefer you to do that in statute as opposed to asking us to go in and do it via rule. That way it's consistent.
Yeah,
The other thing, I have some feedback that I need to get back to you, information that I've documented. There is some additional technical pieces that I think you should amend age 55 with regarding the increase that we did, the $60 increase. I will not take
our
your time.
supplemental.
Yes, ma'am. I will not take your time right now. If you would like to be able to move on to Emma and others this morning, I'm happy to submit that to you in writing. We're happy to come back. and
Great,
talk
well,
to you.
we will be discussing 55 again soon.
Okay.
So let's do that and discuss Yes, it occurred to me that it needs to be not by rule, but by statute. I would agree.
So unless you have any questions, that's generally where we're at. We're supportive of what's there, tweaking some of the report, happy to do that to make sure it's comprehensive for what you all need. But we would kind of support what's currently there as opposed to trying to put some of this into statute this session, because we just feel like we don't have enough information right now.
So just the right language is the additional thing we might look at adding is incorporating both of these concerns, both of these circumstances in as eligibilities for UI. Okay, great. I think that's good, and that advances us a bit, and we'll be taking up 55 again fairly soon.
I'm happy to come back and talk about that.
Randy, Keisha? Okay, great. I think if you're okay with us at the moment,
Yes,
let's move and
Absolutely.
have Emma Paradise chat with us briefly, and then we're going to move to 217 and 101. Great, thanks, Cam.
Yes, ma'am.
Emma, thank you for being with us today, which is great.
Absolutely. Good morning.
Good morning. If you'd be kind of to just introduce yourself for the record, and that would be great.
Absolutely. Emma Paradise. I'm with Common Good Vermont. We're a statewide program of United Way Northwest, serving Vermont's nonprofits. And so I can keep my comments brief today. We are generally supportive of H55 as passed by the House. We appreciate the work House Commerce did in accommodating Vermont's nonprofits, as well as supporting them in their decision-making process with the outreach and education provisions. I just want to highlight the importance of that longer timeline for eliminating the small nonprofit exemption. The nonprofits we spoke with are supportive. They want their employees to have that protection, but they just need that time to really.
To 24, I think.
24, exactly. To budget
I think that's right.
accordingly.
Is that right?
Should be July 1, 24.
Yeah, July
right?
of 24, right?
Yeah. And then the outreach and education piece was something that we advocated for. I think this is a really important way to support our organizations, as nonprofits, unlike the private sector, don't typically have so many resources or information available to them. We serve a similar role as the SBA, but we don't receive any government funding. So everything we do is either fee for service or grant funded. So our capacity is limited to provide.
You mean you're talking about Common Good?
Common
Because
Good, yeah.
needless to say, many nonprofits access government funding.
Right, but the resources for the organizations as employers, as businesses, do not exist. So just as I think the responsibility for carrying out this work was mentioned earlier, we do serve the sector as a whole. We're not a member organization.
How many members do you have at
So we're not a member association.
but how many nonprofits, given they're such a critically important part of our creative economy, and this committee has cared a lot about that, how many nonprofits do we have in the state? Roughly, it's huge.
It's over 6,000,
Yeah.
6,900, I think, approximately. But most of those are small to mid-size. I think almost at least 50% potentially are under 50,000.
Well,
in
and it's
revenue.
important to remember they range from very small organizations, tiny historical societies and arts organizations in our communities, to our hospitals. So it's a gigantic range.
Absolutely. So we do tend to serve the small to mid-sized organizations that don't have, their own systems in place, as well as others. So I think, the outreach and education component is just really important to us, and we will work with DOL to the best of our ability to make sure that that is accessible and helpful for nonprofits. So generally supportive, and just I think maybe the best use of our time is if you have any questions or that we can support.
Anybody have a question?
Comment. Outreach is really important, and there are lots of agencies, including municipalities. My background is in municipal work and small towns, so it's really hard. VLCT is a good source of information, but just understanding HR is it's hard.
And,
So, yeah.
we have a lot of great consultants that do this work, but just, really connecting nonprofits to those resources and making sure they have the support to do so.
And just knowing the rules. I mean, do you use the state website at all? Do you refer people to?
We do,
The-
yeah. I mean,
Yeah.
we definitely refer them there. I think a lot of it information is, a lot to digest, you're an
Has to be
executive director
translated, yeah.
who wears the hat of HR and finance and everything. It's a lot to manage. So just having that really easily accessible for organizations is critical.
Right. So Scott just looked it up and evidently the Secretary of State's website, we've had
Yeah, 6,330.
501c3s.
Oh, number of.
That's just
nonprofits, that's
501c3s.
great.
And there are other forms of nonprofits, obviously, that are not 501c3s. I guess I have a question as we look at educating and outreach. Is the Vermont Community Foundation, would they conceivably be an additional partner?
We do work with them in many ways and they are.
I wonder if Dan would have some ideas on that too, just given how many nonprofits they also are engaged with.
Yeah, we've definitely had some great partnerships with them and they have definitely connections across the state. Are you speaking in the context of this bill or
Yes.
generally?
Yeah. No, in
Yeah.
context of this. So anyway, just a thought that had occurred to me as we look at this.
Yeah.
Great, well, thank you. I think we will, more to follow. But thank you for your help. and Thank you for being here today.
Thank you, absolutely. Appreciate your
Thank you
work.
for your work into the future on this. Again, another great lesson learned in COVID anyway. So we're going to pivot to our next labor issues that are embodied in both what the House passed in H 217 and also in a bill that's in our committee that Damien briefly went over in S 101 when he did S 101, 102, and 103. And so it's been a while. So we're going to get a boot up, I think, with Kelly on 101. But I think to tee it all up, both aspects of the bill, David is going to just kick us off, David Mickenberg, with Working Vermont. Is that right? You're going to tee us up here, and then we're going to go to Kelly, and then Jamie has been able. Oh, God, Jonathan. Well, I'm totally forgetting. Jonathan, as the reporter of H 217, we have asked you to come and give us the overview and of your report on the floor.
Certainly.
And then we're going to go to David. Sorry, I totally.
Oh, it's
I
going
don't know.
all
I'm
right.
on another planet. It says right here.
Thank you, senators, for inviting me. This is my first time crossing the proverbial chamber, so good morning to you all.
Well, welcome. It's good to have you know us all.
I believe I do by name, and I know Ann quite well. Big fan. But if you'd like, we can do introductions if you prefer.
Well, as you know, I'm Allison Clarkson.
Wendy Harrison. We talked a couple of times.
Yes, Wendy,
Yeah.
nice to see
Right,
you.
and we have on screen, we have lost Randy Brock, but there is our chair, Keisha Ron Hinsdale.
Hi, Keisha.
I know
Great,
Representative.
so take it away, John.
Certainly. So this bill, H 217, resembles previous workers' compensation, miscellaneous workers' compensation bills from years prior, but it does do a few unique new things. In the first instance, it sets the annual rate of contribution for the Workers' Compensation Administration Fund, which is managed by the Department of Labor. That is typically a percentage on the premiums issued by workers' compensation insurance carriers. That has ranged from 1.75% in 2013 to 0.4% in 2004. And that funds the DOL's workers' compensation department or entity that settles or manages workers' compensation claims, et cetera. So that sets the rate at 1.5% this year. The second item that instance of the bill amends 21 VSA section 711 which allows for the calendar year premium for workers' compensation to be set. And what it does is, I think during the pandemic, and this was before my time, so during the pandemic, setting that annual rate came down to the wire in past years.
It has.
And so what this would do is that if the legislature does not set the rate would remain unchanged from the year prior.
Right.
Um,
As you'll recall in our walkthrough with Damien.
And then finally, the bill amends 21 VSA section 643A, which details how an employer may terminate benefits provided by the workers' compensation insurance, and how an employee may object to said termination. This enshrines in statute, what was a temporary provision, which allows for, it permits a claimant to file with the Commissioner of the Department of Labor an objection to the discontinuance and seek an extension of 14 days. So that would bring the total number of days during which the liability for the payments continues to 21, because when an employer files with DOL seeking to terminate benefits, they must pay for 7 days already. So that would bring the total number of days in which an employee will continue to benefit to 21. And we heard in House Commerce that there were no objections to this provision. Yes, so, and that was enshrined as a temporary provision in the last biennium. So that's really.
Right. And so you're hoping to set that in statute, that to codify that.
Correct. Ken, did I miss it?
No, sir.
Okay.
Spot on.
Thank you. Try.
And Damien is with us, so if you have questions, Damien is there.
Oh, good. Damien's right there.
Yes, this is good. Thank you. Any questions for Jonathan? Terrific.
Thank you.
Thank you. It's good to have you. So remind us you serve on House Commerce.
I serve on House Commerce. I represent Berry City, and I am an employee of the Vermont Food Bank at my day job.
Which is great.
And you care about modernization and efficiency of processes.
I do very
So I am
much.
glad you are here.
My background is in municipal government, and so I have a few irons in the fire, as it were, regarding standardizing grant processes, et cetera, but for the state, but we can talk about that at another time. So,
But it is relevant to this committee too.
certainly.
It's relevant to every community.
Yeah.
I would agree. Thank
Thanks.
you all.
Great. Jonathan, thanks a million.
Thank you. I'm gonna head
Good
back to
work.
House Commerce.
And just on H17, 217, I take it was a voice vote on the floor, or was it a
Yes.
roll call vote?
Yes, it was a voice vote.
And what was your vote out of committee?
I believe it was 11-01 or 10-01. There were no votes. So,
Great, sure.
thank
Well
you.
done. Thank you very much. Yes, it's one of our must-pass bills. So I think, Kelly, we're going to give you the time we did not have before. We apologize.
No, thank you for giving me time.
Yeah, no. And then we're going to end with Jamie after we.
I
So
did,
Kelly, if you just introduce yourself for the record and then dive right in.
sure, Kelly Massacott. I'm here on behalf of the Vermont Association for Justice. We used to be the Trial Lawyers Association.
Behind you all, Kate.
I need my cape on. Instead of the name tag, next time I'll come with a cape. And I've been an attorney for almost 17 years here in Montpelier at Bigham Fox Skinner. So I did prepare some materials. It might be easier to pass these out if it's okay.
Thank you.
So what is it now called if it's not called Vermont Trial Lawyers? It's called.
VTAG, Vermont Association for Justice.
Oh, right.
The national organization made a change, and so they're all the same. Those are all the same packets. And I will apologize ahead of time. My human spell check was not in, and I do see an error or two in my materials, but
You know
please
what?
forgive me.
We are not the proofreaders, and we care. We're delighted to have.
So if you would allow me, I would love to just give like a very basic background of the comp benefits, because I do think that will help us go through 217. easier. So in workers' comp, there's basically 4 benefits possible to an injured worker. Medical benefits. A workers' comp carrier has to pay for reasonable and necessary medical treatment related to the work injury. We have what are called temporary disability benefits. Those are wage replacement benefits. So this is somebody who is out of work because of the work injury or working less. They get a supplement if they're working less. They get paid if they're out completely.
Sorry, just on that, remind me, do they get paid 100%?
No, I was going to get into that. They don't. Nobody gets 100%. There's really 4 categories. There's the vast majority are 2/3 of their average weekly wage. Then we also have what we call the 90%ers. These are lower income folks who get, instead of 66 and 666, they get 90% of their average weekly wage because they're lower income, very low income really. And then we have state minimum and state maximum. And I do explain these a little bit further down.
Okay, I just wanted to, because as we look at paid family leave as a bill that's in this committee, there's wage replacement there as well, and the interplay between workers' comp and paid family leave is an interesting one. And how duplicative is it, and is it, or anyway.
Right,
So,
and how would that sugar out if that passed? Yes.
Exactly.
So temporary benefits, as I said, those are wage replacement, and they come in those 2 flavors: temporary total if the person's out of work completely, and then temporary partial if they're working some, and then workers' comp is supplementing their wages. Then we have what are called permanent impairment benefits. There's also 2 flavors of those. Those are money benefits as well. And then the 4th benefit is vocational rehabilitation. Somebody whose work injury leaves them unable to get back to their pre-injury wage because of the work injury and not because of other factors is entitled to vocational rehab. And that can be anything from just helping get your resume together, job leads, or for really high income people, it can be academic training, self-employment plan, possibly different things. So I just wanted to give the 4 benefits because I do think that helps us give a framework for discussing the bill. On page 3 there, I do list the 4 different ways that the compensation rate is calculated for the 2 money benefits, the temporary benefits, the wage replacement benefits, and then the permanency benefits. And Senator Clarkson, you're absolutely right. Generally, nobody's getting 100%. That there's one category, which is those 90% of people for that wage replacement. They do get 100% of their average weekly wage for permanency. But generally, people are getting 2/3. And I think that was the original calculation when the statute was first adopted. And I believe that the theory is because workers' comp benefits are tax-free income, it wouldn't make sense to give somebody 100% of their wage, so there's this reduction. But as I point out, what folks are generally paying that 3rd tax rate when they're only making $900 a week. So folks out on workers' comp are definitely not getting as much money as they would be getting if they were working. I mean, that's just the plain fact.
So also interesting to know, which of course many of you may have known, is that I had not appreciated that workers' comp was tax-free income.
Yeah.
Yeah, I didn't know.
Yeah.
So, I mean, Anne probably knew that, but
And some of my clients are frustrated because they're not paying into the Social Security system for those years. So they're losing possible increases to retirement or disability benefits through Social Security. The big one that a lot of people complain about is they can lose their health insurance through workers' comp, and that is not compensable in the workers' comp system. I would love to see that law change someday, but that's not part of what we're here to talk about now.
right, well, maybe
That's
we could tackle that
interesting.
next year.
It's a huge benefit for employees, and it does make the difference. I know for the people I hire, it's a benefit of $10,000, $12,000 a year added to their compensation.
It's a piece of
It's
compensation.
a huge piece of compensation that doesn't get in my view, properly factored in.
And you're saying they lose it because the employer doesn't provide it?
You're not if you lose your job or if you're out of work, the employer may continue to pay their share for that period. But it doesn't get included if you lose your job and,
Right,
somebody
it's
who has
not automatic.
No,
Yeah.
no. And most people have trouble paying their share of the premiums if they're out of work. because they're getting less
Right.
during those weeks anyways.
If an employer wanted to pay it though, they could, right?
Yeah, and every once in a while I do see, and honestly, I don't know if the employer is doing it out of benevolence or side A and side B just haven't talked to each other in the company.
Mm,
I do see it sometimes though, that
Okay.
people remain on their health insurance.
okay.
So using those 4 benefits as a framework, I wanted to just go through quickly kind of the highlights of the bill, and then I'm happy to go linear through the bill, which would probably take a lot less time by going by category. So the first is the provisions in S101, which deal with medical benefits. There's
So-
only,
Let's just remind us, we have 55 pulled up, but 101 is close at hand.
yes,
And we went over it just as a reminder. We have it here. It's a fairly short bill. It's only, 101 I don't have pulled up, 217 I pulled up.
101 is the bill that was in this committee that Damien did a walkthrough of that has several workers' comp provisions, which we support, and we're hoping that you would consider adding to H217.
Yes, you are beginning to propose it and we are actively thinking about it. So yes, great.
First and foremost, let me just point out that there's one provision that's in both bills. So Section 3 of 217, which the gentleman just spoke about a minute ago, making permanent this extension request that injured workers can ask for if their benefits are at risk of being terminated.
Right,
The
the 14 days.
The 14 days,
21
we've had that for several years now. I think everybody agrees it makes sense to extend it. I don't think there are objections. Notably, carriers do get a credit if it's found out that the proposed discontinuance was supported. So if an injured worker gets the proposed discontinuance and they have 7 days to respond, and then they ask for the extra 14, and the Department of Labor ultimately says, nope, that proposed discontinuance was right, those 3 weeks that benefits were paid, the comp carrier gets credit for. So I think it's good for all parties, all the way around, so that injured workers have additional time to collect their evidence. But if the carrier was right that they should discontinue benefits, they actually get a credit for anything paid in that time that the injured worker was trying to fight it, so to speak.
Does the worker have to pay it back?
Usually it comes out of future benefits. It's very uncommon that I see anybody having to pull money out of their bank. to pay
Okay, but
comp
they're
carrier.
owed it.
Yeah, they have to,
Or
they're
they
owed
owe
it, and
it,
it comes
I
out of,
should say.
it comes out of future benefits.
Okay.
Yeah. And I should mention that the 4 benefits we're talking about, not every injured worker is entitled to them. A lot of people have injuries and don't even miss time from work. A lot of people have injuries, miss time from work, and aren't entitled to vocational rehabilitation. So the 4 benefits are the possible benefits, and these are the more serious cases, people who are, being found eligible for all 4.
So
So
you're saying
Section 3 of 217
Is in
and Section 10 of 101 are the exact same provision. And it is making permanent that 14-day extension request.
Yeah, I'm not even gonna look for 101 here, which is somewhere in this file. Who knows where it is?
That's very important to codify and make permanent this
And
extension.
I haven't heard anyone object to it.
That's my understanding, that there is no
Right.
objection.
Yeah, so we just gotta keep it in the bill.
Just gonna keep it in the bill. All right, back to the framework of the 4 benefits. So the first one I've listed here on the bottom of page 3 is the medical benefits. What we have in Section 1 of 101 is
Okay, so maybe we should, if you're gonna be actively talking about 101, let me go and get it, because I don't know where, I know it's here.
sure.
But let me just go and into the hall and get it. Do you have it, Wendy?
I actually do.
You have 101 right there.
It was in a pile, and
Okay.
I was able to find
David,
it, which
you should
I
kind of
cleaned
get
out
normally
all
does
my
that would be
S
great.
bills.
Sorry. Okay, great. I can't find it, so I'm gonna let David kindly go and get it. So if you're specifically addressing it, we should have it in front of us. and-
I think you guys have great ideas in 101, and I really hope you pull them over into 217. my hope.
Yes, no,
Advocacy.
I got it, and maybe I do have it, but I don't think so. And David kindly, and it's a longer bill, so it's not like, thank
Or pull one into the other.
Right, but S101 didn't
Thank you, my dear.
Voting.
go
Okay,
anywhere.
okay, thank God.
I'm
Here you
one
go.
of those things. I'm afraid my language isn't always,
No,
Correct.
I'm new, that's, I don't.
I'm new.
No, you're not. You've been doing this for 17 years, you said.
Yeah, but it's only my third time testifying, so.
Oh, you're doing brilliantly. Okay, so we have the bill in front of us. So let us go with a sectional reference that you just made.
Sure, section 1 of 101.
Yeah.
Which is on page 2.
Yes, because it is a long intent section, purpose section.
This section 1 seeks to correct a problem with the current pre-authorization statute. So under current law, I mentioned medical benefits is one of the benefits. Under current law, there is a pre-authorization process where if a claimant or their medical provider wants assurance ahead of time, they're going to get paid for that surgery, or this bill is going to get covered. There's a pre-approval process that can happen. Basically, the information gets submitted to the workers' comp carrier. They have sufficient time to review it, and they have to give an answer. And it gives everybody assurance that something is going to be covered, and the injured worker isn't going to be left with an unpaid bill, or a doctor's office isn't, upset that something's not getting covered by workers' comp. So that's the current statute. I think this was not intentional, but the way that the current statute is written, it does not include durable medical equipment, DMEs, we call these. Things like hearing aids and wheelchairs and hospital beds and orthotics. Again, I don't think this was purposeful. I've talked to folks at the DOL. I've talked to the prior ALJ, Phyllis Phillips, who helped write the rules the last time around, and nobody can really explain or remember. It might just been in the language. It might have been that the current language uses the term treatment instead of benefit. And something like a DME is not necessarily a treatment, it's an assistive device. And so I think it was just an oversight, but the result is I have a state of Vermont client who was a game warden for over 20 years, and he has an accepted claim for hearing loss. And they've paid for his first set of hearing aids as part of his claim. He needs another set. And right now, because a defense attorney got involved, they're saying we don't actually have to prove this type of medical benefit because it's not technically covered because it's a DME. So all we're seeking to do in section 1 is to mirror the language of what defines a medical benefit to make everything subject, if needed, to pre-approval, to the pre-authorization process. So it's just making sure somebody with hearing aids or somebody who needs a wheelchair can submit the request and get a yay or nay before the thing is actually issued, and they might owe many thousands of dollars to find out how might not pay.
So forgive my ignorance on this, but I would have assumed that pre-authorization would take into consideration any either device or surgery or medical intervention, device or medical intervention that would solve the problem and not be limited.
I think that was the intention. Honestly, I think it was just an oversight with using in the drafting with using the word treatment instead of benefit, I believe. The statute's been around for several years now, and it's been very helpful because before the pre-authorization statute, people were in a real catch-22. There was no way to force an answer from workers' comp and move forward with a surgery. It really was a problem. So it's a great statute. It just needs to be cleaned up to mirror the language of what medical benefits are in a comp claim.
So I'm just going to ask our ledge counsel if he's present. Damien, are you present? Listening to us, or are you? I know you're there up there on the screen, but yeah, I know.
Jamie did not appear.
No, I know. I'm a little. So, okay, great. And these are the asks that are represented in your testimony that you've just given us?
Yes.
Somehow.
Yep. Everything's outlined exactly as
Can-
I'm going
Can I
through.
just ask a quick question about that? If the employer were going to provide, say, the hearing aids anyway, no matter what they cost, would you still want a pre-authorization?
Pre-authorization, yes, we need the fact that the statute fixed, but pre-authorization doesn't get used all the time. There's, you know, it's
Okay.
only when it's necessary to be used. It's not
Okay.
used for every treatment. It's not used for every visit, certainly.
Because I see the logic of it for a procedure, because you can't undo that.
Right.
But, okay,
And I know that the department has expressed concern that they're worried about perhaps, expressed concern to me that their only concern might be that it might add to the workload for the case specialists. And from my vantage point, I really don't think it will, because the vast majority of workers' comp carriers are pre-approving DMEs anyways,
okay.
even though they're legally not required to. They're
Okay.
doing it. They're doing the right thing, but there are a handful of defense attorneys who, who are advising
Oh.
carriers who say, you actually don't have to pre-approve these. We have the right to not pre-approve these. Let's not pre-approve these.
Okay,
So the vast majority are getting pre-approved already through the
Okay.
process. Even
Okay.
if legally they're not required to be.
Okay, so.
But
Thanks.
like my gentleman, the game warden who
Yeah.
needs these hearing aids, I mean, he's like, I'm not in a position to pay 4,000 or 5,000 and not be reimbursed. Like, I need to know this ahead of time. And obviously I would challenge it if they were denying
So
payment.
Okay.
I'm also trying to anchor our committee in your testimony, and it's on page 3.
3, yes.
Right, okay, terrific. So that is that's your
Medical-
interest in section 1.
And that's the only provisions that regard medical benefits. So that's the first benefit we talked about. And now we're moving on to the second, which are temporary benefits. And these are the wage replacement benefits.
And this is in section,
These are sections 2, 3, and 4 of the bill. And so of 101, we're on pages 4 through 9,
right,
sections 2 through 4.
got it.
And
these
again-
involve temporary benefits.
And again, temporary benefits are wage replacement benefits. These are replacing the wages. And we had that chart earlier on in my materials, which show the vast majority of people are getting 2/3 of their average weekly wage. So the first one I spoke about briefly when I was in here a few weeks ago is increasing the dependency benefit. For those wage replacement benefits, the law currently allows $10 per week per child when somebody is out on temporary total, when they're out of work completely.
$10 per child per week.
Correct.
And sorry, just before you go any further, when we're talking temporary benefits, do you have an average of what temporary means, the average length?
You know, I really don't know, because in some cases it literally could be a week. In another case, it could be 2 years. It depends on the severity of the injury.
But 2 years is a lot more than temporary.
Sure. If I can explain, so somebody gets injured and a lot of the time they're going out of work or working less while they're recovering from the injury. That's when they're entitled to these temporary benefits. At the end of their recovery process, when they're as good as they're going to get, when they've plateaued, and again, in a minor injury, that might be a few days. In a major injury, I've had people, be in Boston for 2 months in rehab, and then they're looking at 2 more years of recovery. But when they finally plateau from their injury, that's the end of those temporary benefits. So there's not a cap on those. And it really depends on the severity of the injury, how long they might be on those temporary benefits.
So, forgive me.
No, that's
I mean, I
okay.
know Ann probably knows it
No,
better.
I
than-
don't.
Well, you're more an insurance person than I
We
am.
don't do workers' comp.
I know we do. Here,
It was here. When I came here, it went there, then
and
it
then
came back.
Ken came back here. So, I just, it does strike me, we need, yeah, so it is the expectation with a temporary benefit that people still have their job through all this. Oh, here's Damien. Damien, hi, we had a question for you a little bit earlier, but we're moving with Kelly's suggestions on how to improve 101. And so we just talked about section 1 and adding,
I think we're adding one
adding,
from 101 to H55.
that is certainly what is being discussed. But in 101, we're talking about fixing that pre-authorization section and adding the durable medical equipment to it. And now we're on to sections 2 through 4, the temporary benefits. And I asked, what does temporary mean? And Kelly's saying it could be 2 weeks or a week to 2 years. And I guess my question is, what's expected of the employer during that 2-year period?
Sure. So a lot of people misunderstand and think their employer have to hold their job for them and it's illegal to be let go while they're out on comp, and that's not true. There's obviously family medical leave protections, federal and state, if the employer meets the eligibility for that. There is, under the workers' comp law, a right of reinstatement. So if an employer is large enough and if the injured worker recovers in a 2-year period, then the employer, if they're large enough, has to offer a position at the company, basically the first position that's open that they're physically able to do and have the training to do. So a lot of people do lose their jobs if they're out and have a pretty substantial injury and have a very long recovery. They lose their jobs, and that's legal. That's
Right.
That
No,
happens.
I hear that. I just think the word temporary is a little misleading. That's all. I know it's a term, but it does seem
Well, I think it presupposes that at some point they will be able to go back.
to go back to.
Right. It's during the medical recovery process. Temporary basically reflects the medical recovery process.
Temporary in a long life. You have to live till 95 for it to be temporary. Okay, got it.
So,
Well,
Oh, go ahead,
it is temporary, limited to 2 years.
no, I just
Because I
think that
thought
it,
it could go on.
it actually could go on longer. That right of
And is
reinstatement.
there any limit?
No, it's
No.
I don't think in,
it doesn't appear to
yeah,
be.
okay,
No,
okay.
no.
So I
But,
think that's a question.
Certainly workers comp carriers who believe somebody who has been on temporary benefits too long work to show they've plateaued, they've recovered,
Right.
they're at that,
Right.
stabilized.
So there's
point.
not a hard fast.
No.
Okay.
So the first provision that we are talking about for temporary benefits is in sections 3 and 4, which, and I alluded to briefly when I was here a few weeks ago, is increasing that dependency benefit. It's not changed in over 41 years. It's been $10 per kid per week for 41 years, and it's time to update it. It should be updated to $20 per child per week.
$10 bought a lot more food per child 4 years ago, never mind 40 years.
Well, people are saying $20 isn't enough.
I think most adolescents could eat $20 worth of food in 10 minutes.
I was gonna say
Yeah.
one sitting.
And there is a rule that says, basically the parent has to be financially responsible. Either, they live with them or they have financial obligations and those kinds of things.
They're buying the food.
Yeah.
Okay.
The next section that affects temporary benefits is section 3 of 101. So we're on page
That's what
5.
we were just talking about.
Yep, we're on page 5 of 101, section 3. So this affects, I just want to be clear, this affects a very small number of injured workers, but it's really important that we correct this. Remember that the wage replacement benefits, temporary benefits can either be temporary total if somebody is out of work completely, or they can be temporary partial if the person is working some, but they get a supplement from workers' comp. The way that temporary partial disability benefit is calculated is based just on the 2/3 flavor version of compensation rates. It doesn't take into account that some of these people are the 90%ers, as I call them, or the state minimum, as I call them. I can go into more detail, but I'll just give you an example. It's on the top of page 5 of my materials. So this is an actual client I had. She was earning $523.64 per week on average before her injury. She was very seriously injured and had actually 2 back surgeries. The second one was a a re-herniation of a disc, and she was inpatient. So she was out of work completely. And under the rules, she was a state minimum rate, which at that time was $498 a week. So when she was working, she was getting $523.64 on average. When she's out of work on comp, total temporary disability, she's getting $498. She's dying to go back to work. The comp carrier didn't even push her on it. She couldn't go back to her prior work. It was farming. She had to do something physically easier. She got herself back to work. And I said, let me explain to you, just because of your wage and where you are, I just want you to recognize you're likely going to be getting less money. I applaud you for going back to work. I just don't want you to be surprised about this. So she went back to work, working full-time, earning $150 a week. She was I said, sorry, part-time.
Okay.
Sorry, I meant to say
I was
part-time.
gonna say.
And 150, that's not good pay if you're working full-time, sorry. She was working part-time for $150 a week. And the way the TPD, temporary partial disability calculation is done, she was due this $249.22. So I'm throwing around a lot of numbers, but the big end all be all is she was entitled to $498 when she was out of work completely. And that's tax-free. Or she was getting $399.22 between her gross wages, which are subject to income tax, plus that supplement of temporary partial. She's getting $100 less a week when she's trying to work, when she's trying to get back to work. It's an absolutely illogical result. It disincentivizes people from trying to get back to work. And it's just not fair. And again, I think it's an oversight because originally the compensation rate was based on that 2/3. And then at some point, the legislature added in these other flavors, the 90%, but they didn't fix the calculation for TPD. So temporary partial disability. So again, this really affects a very, very small number of people because a lot of people don't get temporary partial and even fewer of them are maybe the lower income, but for the people that it affects, it's a major, major issue. And I can't believe any of us want somebody to get more money being out on comp than what they would be entitled to with
Right.
working.
No, I think that's the kind of thing that makes everybody nutty.
It's like our benefits cliffs, kind of.
So the next.
So you have a solution.
Yes, and it's, I can certainly go through it in the bill, but basically it's taking, what would they have got if they were out of work completely? Deduct their gross wages. That's the supplement amount you get. And it's a lot
Okay.
easier math,
Oh, yeah.
frankly. It's a lot easier math and I believe the department agrees with that,
You're right.
maybe.
Well, maybe-
I don't want to speak to that right now.
Okay.
Okay. We're not, and then, so have you been in touch with Damien so that Damien has the heads up on some of these fixes he can start thinking about if we agree to go down those roads?
Yeah, they're in S101. It's spelled out in S101.
All right, so these are all the fixes in large.
The fixes are in here. I was
Okay.
trying to give the 20,000 foot
Sorry,
view.
Okay.
Yeah,
Yeah.
I thought you were saying, asking for fixes on top of what was in S1.
No, I didn't want to speak or assume the department supported it. I don't see people having objection to something that is going to correct this issue because
right.
people shouldn't get less money going back to work.
Total. And so that's at the bottom of page 5 and top of page 6, it looks like.
Of my materials?
No,
of the
of
bill.
101.
Yes, correct.
Okay.
Yep, absolutely. And then the next section is section 2, and I'm sorry, I'm kind of going backwards, but I'm trying to do it within the framework of the benefit. So we're back on page 4 of S101.
Right.
Page 4 of S101, which is page 5 of my materials.
Section 2. Yeah.
If somebody is out of work on temporary benefits and they have some work capacity, but their own employer can't accommodate those restrictions, they have a job to return to, but their employer says, we only got heavy duty labor, I got no desk work for you. Under current law, the insurance company can make the person go out and do work searches looking for work. Because if they get work and start working, then it reduces what they have to pay, and it's that temporary partial category. There's a couple of times that it just doesn't make sense to have somebody do those work searches. One is they still have a job to go back to with that dependent employer where they got injured. Somebody could have a job at the manufacturing facility. They're out of work for a carpal tunnel surgery. Their doctor says you could do one-handed work. their own company says, we don't have any one-handed work, call us when you're all healed up. We've got a job for you to come back to. The comm carrier can say, go out and look for one-handed work, even though you've got a job to go back to. It doesn't make sense to make people go out and look for work when they have a job to go back to, or if they're headed into surgery. And there was a suspension of this work search requirement during COVID.
Right.
And frankly, once it was over, I don't see comm carriers actually asking a lot of injured workers to do these work searches. I think they kind of have adopted, maybe this doesn't make as much sense, but it does still happen, and it's unreasonable to make somebody who has a job to go back to with the defendant employer to go looking for a job somewhere else. It's also a pain to business owners who have to deal with those applications and phone calls when the person is not actually likely going, either wants or going to capture that job they're applying for. Likewise, if they have a surgery coming up, serious back surgery in a month or two, you want me to go out and look and ask people, one thing to go for maybe to look for temp work, but to go out and look for jobs and ask employers to hire you when, 8 weeks from now, I'm going to be out for the next 3 months. These are illogical results. And we just think that there should be those exemptions for work search requirements.
Okay.
And then also as part of that, we are encouraging that there be a 3 per week limit on the work search requirements. I believe that's what it is in UI. I'm not sure, but right now it's kind of Wild West. Insurance carriers, I've seen some insurance carriers tell my clients, you've got to do 10 work searches a week. The whole result of somebody not doing these work searches is that they risk getting shut off from their weekly wage replacement benefits. It's just about trying to replace those wages and save some money while they're recovering from the surgery. So it's serious if somebody fails, or in the carrier's eyes, fails to do those work searches.
Just, if you don't know the answer to this, it's fine, but how many carriers are there in the state?
I don't know the answer to that.
Like 20, 10, 50, 100?
If I, not 100.
Actually, the insurance, okay.
Jamie,
Is it more than
Jamie,
comm carriers?
Concord, yeah, they're good.
Yeah, I mean, if
I think they're consolidated, of course, depending upon market share, but they're.
Okay.
I guess I would be surprised if there were more than 2 or 3 dozen, because it seems like the same ones are always coming up, same ones are always
Okay,
coming
so
up.
more than 50.
Maybe, yeah, I'm not sure.
All right.
And some companies are obviously self-insured.
Right.
They don't
right.
have,
Okay. I'm just thinking in terms of communication.
we do see a lot of the same, Liberty, Zurich, Travelers, it's a lot of the same companies.
Okay, and I'm sorry.
Money change,
okay.
I'm sharing.
So sadly, we're about to lose Anne. We
Okay.
have still Keisha, so we have a quorum. We need to give
Oh.
Jamie, how many minutes?
Okay, we
do you
do
need?
have Keisha.
I can do you a favor if you do me a favor. I can come. It doesn't sound like you're voting today. I can come down.
So we're not voting today. We're really just getting into the meat of it. If you don't mind, and then we can finish with Kelly by 12, which gives you 12.
Okay,
13.
I've got to leave because I've got to get lunch and get
Got
some
it.
money
But
chairs.
we have
so
Keisha, so we
I'm-
have,
yes.
as long as we have Keisha.
And I am chairing today,
Oh, good luck.
so I have to be.
Okay,
That's
great.
probably a good idea.
So Kelly, let's keep moving. Jamie, if you don't mind, let's reschedule. That would be great. Okay.
So we've touched on the temporary benefits. The next,
The work searches.
right, and the work searches are part of that temporary benefit regime. It's
Right.
about those you have to do the work searches to keep yourself entitled to these wage replacement benefits. The next benefit, these permanent impairment benefits, these are money benefits. This is section 5 of S-101. And which is on page 9. And this is page 6 of my materials.
Okay.
Basically, this section just seeks to codify existing DOL guidance about cost of living adjustments on these particular benefits. The statute says there needs to be 26 weeks before cost of living adjustment is applied to temporary benefits. It's silent as to permanent impairment benefits. It's not always been consistent with how the department case specialists have decided that issue, but there is clear guidance from the prior director that I believe the department still stands by. And so we're just seeking for that clarity and codification in the law.
Okay.
And then the last two really have to do with when there's problems and when benefits aren't being paid when they should be in
And
claim.
that's in section 6.
5 and 6, yep.
Okay, so that's an additional.
So we're
part of
still in-
section 5.
Yep, we're still in section 5 and on S101, which is page 6 of my materials. So section 5 seeks to increase the penalties owed when a workers' comp carrier fails to timely issue an injured worker's benefits.
Right.
There are current penalties in the law. And they can be found on page 11 of F101. The current penalty is $10 or 5%, whichever is greater, if a payment is even a day late.
10%.
The existing law is 5% or $10, the existing law.
Why am I not?
This-
I see.
Subsection 2 on page
5%,
11,
It says 5% of the benefit or,
and the $10 is right above that, the $10 on line 8.
oh, got it. Okay.
And again, this was written a long time ago, so the 10% may have actually applied back then, but it's usually always the $10 may have applied, now it's usually the 5%. So there is a 5% penalty if the carrier is a day late. If they're more than 21 days late, it's a 10% penalty. Unfortunately, carriers are not timely issuing payments routinely, and I'm not saying fault, purposeful, not purposeful, it just is happening. There's something called auto pay, as I understand it, with insurance companies, where they set up this person's out of work, auto pay for the next 3 months, they're just going to get their regular payments, but they set an end date for that auto pay. And if my understanding is if the adjuster doesn't go in and extend the auto pay period, then the payment just is not issued. I get several calls a week from clients who say, I didn't get my payment today. Now, during the pandemic, it was like, is it the bank? Or excuse me, is it the employer? Is it the post office? Because the post office was a real problem. A lot of people have direct deposit now.
What proportion?
I actually don't know the answer to
That
that.
would be really good to
That
know.
would be, it's really helpful. And I urge people to get on it because it's much easier and proof positive.
Totally.
Proof positive if a payment is late, because before direct deposit, carriers would say, no, I think we've issued it on time. And it's bulk mailing. I have no post date to say, no, it was mailed 3 days late.
Yeah.
So direct deposit is used a lot. I don't know if the department knows. I would say at least probably more than half my clients are on direct deposit.
Okay.
And maybe unrepresented claimants, that's much lower, because I do find that's one of the first things when I start representing somebody to say, did you know you can be on direct deposit for
Right.
this?
Well, at first it eliminates the post office and also, I mean, which it may or may not be a problem, but it also is just so predictable.
Right.
You know when it's hitting always.
Right. And if something's late, I have the evidence right there to show that it's late.
And then the state could know.
And then the
too.
state can know, exactly.
So
The
new
direct,
language here is.
the direct deposit is great, but the problem is payments are still late, and this 5% benefit or 5% penalty is not a strong enough penalty to change the carrier's behavior. This is happening all the time. And I would say I get at least 6 calls a week from clients who, I didn't get my check, I'm on direct deposit, it's not my account. And folks are already living paycheck to paycheck, most of them. Then they get injured and they're getting even less money than they were getting when they were working. Now they're not getting their pay always when they should be getting it. And so automatic payments coming out of their bank accounts, overdraft fees, penalties, people are incurring a lot of extra charges if their payment is even 1 or 2 days late. So we're proposing a graduated penalty scheme where if it's the first time in the claim it's late, 5%. If it's the second time it's late in the claim, 10%, and on up until 20%. I know that that seems like a high number, but I think it's necessary to really change behavior. And the biggest thing to understand is this is not going to cost the carriers a dime if they issue payments on time. So complaints about how much this is going to increase the cost of comp carriers is only due to malfeasance or issues with them not getting their payments out on time.
Which is what we're gonna hear from Jamie about at a later date.
Sure. And then it proposes to change the 10% penalty if it's over 21 days to 25%. So the very last one is section 6. It's on page 6 of my materials, which is page 12 of S101. All this is doing is seeking to codify what I actually understand is the department's current position. This only seeks to change or codify costs. The statute does deal with attorney fees as well. There's nothing in here that's actually changing anything about attorney's fees. Damien can speak to this. He may have changed around the language or tweaked some, which he often does when he is in a statute. But there is no change to attorney fees at all here. The only thing that's changed is costs. And it basically clarifies that costs are available to an injured worker at both the informal and formal levels of the adjudicative process. I've been practicing for 17 years and I didn't realize that they were available at the informal level because of the way the statute was written. And I spoke to Dirk Anderson, the current director, who said, no, we believe they are costs already available. I said, I think we should clarify that then, because there's been a misunderstanding. In my firm, we've been doing workers' comp for almost 40 years. And if we were confused about the availability of costs at the informal level, then it should be clarified. And again, this is nothing different than what the department has told me is already their position on costs. I know that it's a lengthy bill. There's a lot of language in here. I know you folks have been great to give me a while to sit here and talk, but honestly, these changes are either clarifying and codifying what's already the practice, or it's making very minor, sensible updates to the comp system. And I just urge you to please consider bringing them into 217.
Right,
Yeah.
thank you. Yes, that is certainly the question that's being asked. Yeah, so
Thanks.
I think that's our hope and expectation. So thank you. Kay, should you have a question? You come back to us in person, which is nice.
No, I don't have a question, and I see it looks like we've lost Senator Cummings and Senator Brock, but I think
he is chairing the money chairs meeting.
Right, and I think it's indicative of sort of the future. You know, I don't think Senator Clarkson, you have had an opportunity to say we're probably trying to wrap up April 28th because the following week will be closing out early in the week, and May 3rd would be.
Right, I haven't said that. I think the understanding is that we are trying to get these bills done in a timely fashion, and we have, yes, until the morning committees are shutting down at end of April, early May. So,
yeah, and I just have a feeling, given the makeup, we have nobody on this committee who is unlikely to be on a conference committee, down to our newest member. So I just want to set our intentions as we start to look at these bills. People are asking if they can testify and where we are going with things. I would say I would like us to start to set an intention to fold H55 and H217, our UI and workers' comps bills that have come over from the House together, and add the pieces that we can agree on from S101. And right. I think, we've heard a strong case. We're going to hear some concerns raised, but that's the intention around these bills. So I'm telling that to the general universe as well as our committee. That's anytime we take up a bill now, I feel like we should start to be clear what our goal is by the end of April.
Right, that is our goal,
So age 55 and age 217, and then some of age
S101.
S101.
Right.
Yeah. I mean, if it was up to
Okay.
me, I think there's a lot of neutrality to support for those pieces from S101. You know, they're small but meaningful changes. I know we're going to hear some concerns raised, but yeah, that's why we're going through S101 again.
That's
Right.
helpful. Thank you.
Which is, so, well, we hadn't ever had Kelly come and walk
Exactly.
through all her.
Yeah.
So that was important. We had a walkthrough a while ago with Damien when he did 101, 102, and 103. So it's for us the first time of really substantively discussing 101, which is great.
May I just say briefly,
Yeah.
there's two things in S101 that have been brought to my attention that I think should be tweaked if some of these provisions are going to be brought over. The first is on page 7 of 101.
Okay, we're going back to section 4 or section 3.
Section 3, page 7, line 12. Senator Brock brought up at the very beginning when Damien did the walkthrough, the word submits. And I agree that should be tweaked to really reflect the employer's receipt or the carrier's receipt. This is how long they have to issue the benefits, basically. And so instead of it being vague, the employee submits, because what does that mean? By mail, by fax,
Right.
you know? It should be based on the employer's receipt of that information. I agree with Senator Brock, that's a necessary change.
Okay.
And then
So
this,
based on the employer's receipt.
yes,
Or the carrier.
yeah, after the employer carrier's receipt. And then the second one is.
And is Damien, are you with us? You got that?
With you, I'm taking notes.
Okay, great, thanks, just wanted to make sure. Yeah, and the second one?
And the second one is on page 13 of S101.
Yeah,
And this is section 6, first line. It should say shall instead of may.
it's B, section B, the commissioner may
It should be
award necessary costs.
shall
I'm sorry.
on line 1
Oh.
And
instead of may. When this was being drafted, again, I didn't even realize that costs were already available at the informal level. And I guess I was encouraging, or the sponsors were encouraging discretionary award. But then when Dirk Anderson pointed out to me, no, it's already mandatory. That should be a shall there instead of a may.
so that's actually current law.
That is
shall.
correct.
Or to current understanding.
Current understanding is shall. Is that a fair way of putting it?
Yes. Yeah.
Okay. Right.
Thank you so much. And I really appreciate it. This is my entire life, is this tedious comp stuff. And I know you guys are always switching from major issues and over here. I'm amazed when I come into these committees and amazed, when I talk to Damien and he's going from here, and here, that you folks juggle so much. So thank you so much for the opportunity just to talk about these things and
Well,
try to explain it, because
Yeah.
the bill is long, but honestly, I feel like these are very reasonable, fairly minor changes, honestly. So
minor and
Thank you.
reasonable.
that's what I try to do.
Okay, I think, look, given I have Jamie in my view shed, I think it's in the eye of the beholder. But I think clearly there is some thought that these are minor and useful and very doable. Okay, great. Well,
Thank you so
Kelly.
much.
And Kelly, thank you. Thank you for your thoughtful contribution.